Hey guys, and welcome to the weekly docket. Hey guys, good morning. I think we're online here so we can get rolling and get the day started with the bad news other people are having. Let's take a look at what's going on. It's not the craziest week, which is good, but still some cool things. All right. I just saw this breaking news on Friday that they finished the hearing for Ethan Crumbley, who, because of the age he was at the time he committed the crimes, had to have a special hearing to see whether he was eligible for life without parole. And the judge decided that he would be. So that's bad news for him. And yeah, he was really young when he committed the crime, but he got his due process and the chance to convince the judge that he was a special case and shouldn't receive the potential maximum punishment. But guess what? It's not going to work out for him there. I think it looks bad for him. Good morning to Scotland, a country that is often brought up here beyond any reason. And also Texas. Good morning to Texas as well. And we shall not mess with either one of those. Let's take a look at this. Taylor Schabusiness modeling her Halloween outfit and doing it convincingly, I think, during her sentencing hearing. This isn't ideally how you want your client to look when they're going to their sentencing hearing. The idea that she could get off for being crazy had already been decided, and this helps the effort of that, but I don't think it helps the effort of trying to get the judge to give you something less than the most severe sentence. So she's not very appealing, I think, at this point, but she is appealing. As you can see here, I filed a notice that she intends to pursue post-conviction relief. So the judge sentenced her to life without parole, not surprising, but keep that in mind for when we come back to a case at the end of this. She killed one person in a horrible way and got life without parole. So, and I think that's appropriate, but still. Hello to Michigan. Yeah, Michigan and Missouri. In Oklahoma, and from the upside down, Australia. All right. So that's Schabusiness' story. She's going to, try and seek an appeal perhaps, but I don't see where that's going to go anywhere. Down in South Carolina, and also known as the worst Carolina, let's talk about Alex Murdaugh. I have to use this picture at least. I should change it, but just everybody is looking kind of weird in that picture, don't you think? Anyway, his attorneys filed a supplement to motion to suspend appeal and for leave to file a motion for new trial. The titles of legal documents are always very exciting and clear, very engaging. No way you go to sleep reading this document. What was that about? Well, here it is. Here is an affidavit of Timothy Stone. And this is to show that the Tim Stone, who deleted a post and said, look, I'm sorry about what I said or whatever, was in no way connected to the juror. He says he was never married to her, doesn't know her, didn't paste on this, whatever, Walterboro word of mouth site or whatever. This guy's saying that wasn't me. So Murdaugh's attorneys wanted to put that into play. But the South Carolina Court of Appeals wrote back, the court received your supplement to motion. What? Oh, yeah, it is blurry. It was like a fax copy or something. That's straight off the Court of Appeals site. Yeah. The court received your supplement to motion to suspend appeal and for leave to file a motion for new trial. If you wish for the court to take some action on your filing, you must file a motion pursuant to Rule 240. So there's a kind of exciting and engaging correspondence you get back from the South Carolina Court of Appeals if you file something that doesn't exactly fit inside the box, because Court of Appeals stuff is highly technical, way more so than trial stuff. Yeah, see, look at this. This is the kind of thing people in Australia can do that I don't know how to do. I'd have to turn my monitor upside down or something like that to read this, I think. So that's very cool. Yeah. That picture always struck me that way. Yeah. The affidavit, if that's the one you're talking about being blurry, that was how it appeared on their website. But I guess, well, I don't really know why. So can we talk about South Carolina? I call it the worst Carolina but now, having said that, it is also in second place in my heart, which is not so bad, right? Except that there's only two. And Ricky Bobby would say, if you're not first, you're last. Yeah, but I still resist, regardless of which Carolina you think is the best or the worst, that they just call it the Carolinas. I mean, what's the point of having this whole state split if we're just going to confuse people like that? And there is a lot of distinguishing between North Carolina and South Carolina, kind of like Virginia and West Virginia is two different things. At any rate, what's going on, of course, in this Murdaugh trial, the idea is there's an improper communication with the jury, and that can be serious. But if it's by a court official, it really changes the game, because instead of having to show it with something other than like good morning or whatever like that, it really, you have to show that there's no way that what they were talking about could have influenced it. So it would need to be something like good morning or something like that. You can't have a juror was walking through the grocery store and heard somebody talking about the case, but it didn't influence them or whatever. If a court official is talking about the merits of the case with the jury, that's a big problem. It's just a big problem. And while I may be in the minority of attorneys watching this case who thinks they got the right guy on this, irrespective of whether you think they proved the case or not, it's just my feeling that I believe that he did do it. Having said that, I still think if what the defense is saying here is true, then he should get a new trial. That's the way the system needs to work. Oh, I'm blurry. Oh, well, and I feel blurry. I will say that. So I don't know why that's doing that. Sorry about that. You're missing nothing in that regard. And hopefully the slides themselves are clear. You're right. How about Richard Allen and what's going on with his case? And before we talk about that, we'll get into some more regional rivalry stuff. Is North Carolina versus South Carolina like New York versus New Jersey? I can't say, because I don't know what New York versus New Jersey is like, because I think, well, my wife just gave a thumbs down there, but most of those people have moved here. So I'd have to just ask one of them, because that's who's always standing in line at the bagel shop, and they could probably inform me of that. But for South Carolina versus North Carolina, it's maybe some sports rivalries and stuff like that, but not quite as bad as I'm making it out. So let's see here. Richard Allen, a lot of issues on the evidence in his case that are subject to reasonable discussion, but right now there's some procedural posturing going on. And if you recall, out west in Idaho, Kohberger's team does not want cameras in the courtroom. They do not want them there. And they say that can prejudice his right to a fair trial, because other witnesses can see it, a circus-like atmosphere, and exposes people to harassment. Even the state says that. Undue focus on Kohberger. So the defense says, if you let cameras in, judge, you have violated his right to a fair trial, which of course could put a conviction at risk. But flip the script over to Richard Allen's case, and it's the state who does not want cameras in, as the defense is requesting them. So totally the opposite. And of course, a lot of people in the United States and people who watch U.S. cases think you got to show these cases, man. The public has a right to know it. And I'm generally in favor of it too. But, that's still the minority of cases in this country, and definitely the small minority of cases around the world, as most places do not televise their criminal cases. We do sometimes in civil cases too. And it's really typically where it is allowed up to the judge to do it, and parties make their arguments. And here the defense has said they want the cameras in the courtroom, and the state says no. And the state says here that the court had previously worried about extrajudicial grandstanding. And you'll see through, I think, what the state is saying here is really calling more toward the Odin stuff that was filed in this last motion. And they think that's over the top, aimed at social media. I stop here for this. I got to say this. Virginias and Carolinas are separated by culture, and that's I agree, true, because I'm actually I was born in Charlottesville, Virginia, and grew up just south of that in the countryside, and then came here. There's some differences, sure, but Virginia, of course, has cultural differences. It's substantial within the state because of proximity to D.C. and how that gets urban up at the top versus places where I grew up. Anyway, sorry, this isn't supposed to be about where everybody lives and everything, but I can't help it. Someone who lives in Scotland, that was settled by Norse Vikings, object to the cultural appropriation of Odin. And I sustain that objection. I totally agree. More so, of course, it's just exciting because everybody over here got excited about the Viking show. And I'm sure that was popular around that time. And it was so awesome. And everybody wanted to be a Viking and stuff. And we wanted to have shield wall and axes we could throw and all that. But it doesn't mean that people who like Odin or whatever are out murdering teenagers. That's total nonsense. Not that somebody couldn't do that, but people who don't like Odin are frequently murdering people. So it's not an Odin thing specifically, I think. The point is West Virginia is nothing like Virginia. Yeah, and yeah, that I agree with that. Yeah. I think that's generally speaking true. But there are some parts of Virginia. Yeah. I mean, I was way out in the boonies in Virginia. So even within Virginia, there's a lot of differences there. But all right. So what else did the state say? Or do you think their arguments are compelling? I would think most people watching this would think you should show the trial. And if the defendant wants the camera, then the state has no business saying no. I think that would be the general thought people would have. But note the state says that the defense is continuing this extrajudicial grandstanding through their motions. Yep. The modify safekeeping, that's where the alleged prisoner of war conditions came up. And let's see what else they said. They create the same concerns, Judge, if you're broadcasting all the pretrial and trial proceedings. Given that an attorney is immune from liable proceedings for statements made in open court, it's always a threat. It can be turned into a circus. Okay, the OJ case became an absolute uncontrolled circus, and not all OJ's fault, right? The judge should have controlled that better, but it's a fair concern. Usually you see the defense bringing the concern. The defense counsel continues to use inflammatory language in pleadings and statements that are simply not true, and there's no reason to think they won't continue using this supercilious language in court, designed as sound bites for recording on the national stage. The prisoner of war statement. And fanciful defense for social media to devour. Have we devoured that defense? I think this is fair by the state that whether there's merit to the Odin defense or not, it certainly was the thing that got this case back in the media big time. That's all this. So the defense has already moved for a change. And this is a good point, I think, by the state. The defense has already moved for a change of venue, citing prejudicial publicity. And so if you're allowing broadcasting, the publicity will become more pervasive and without boundaries. So, yeah, I mean, if the defense is saying this case is getting too much attention, we have to move it to a county where there's no attention, but also can you show everything about it on TV? That does seem a little inconsistent. So good point by the state, I think. And good morning to Liverpool, UK. And the defense is going to attack not only evidence, but credibility of those who investigated the case. And that's nothing abnormal about that. And the defense will grandstand on camera about the imagined bad motives and disparage not just the evidence, but the state. It does not increase public confidence in the system. I think that depends on the nature of the complaints, because if you do disparage somebody acting for the state and it turns out they were acting wrongly and that gets brought out and it gets corrected in the system, that could increase the confidence of it. If you don't want to show it because it happened, that decreases the confidence of it. So it really is only an issue if they make these allegations and you can't convince people that they're wrong. And then this is always a fair one, I think, a fair concern, separation of witnesses for testimony. If you're putting it on TV, it increases the chance that witness B, who's not testifying to another day, sees what witness A says on social media, Twitter, Instagram, or whatever, even inadvertently. And if it's not broadcast, that can't happen. So that, that's a concern. It doesn't overweigh broadcasting all the time, of course, but that's at least a fair point. The potential members of the public seeing gruesome images. Having said that, I think the courts do a pretty good job now making sure that the really graphic scenes are not displayed on camera, and the people who film it do a pretty good job of that. Allowing cameras can result in a circus atmosphere, both in person and online. I hate to inform you, there is going to be a circus atmosphere online, no matter whether you show this case or you put it into an underground tunnel and no one with no lights and no one ever sees or hears it. There's still going to be a circus atmosphere online. 15-second clips taken out of context can race around the world in seconds. Yeah. But, if somebody in Taiwan is hearing something that's out of context about this case, it really doesn't matter. It matters what the jury sees and hears. So if the jury is seeing and hearing social media stuff, that is definitely a problem, just generally. And then if witnesses are watching other witnesses, that's a fair concern. What people in other countries are seeing about this trial doesn't affect how the trial turns out, I don't think. I see this. I didn't bring this up, but I did see a channel had it on. Something about one of the Darrell Brooks jurors finally spoken up and said that every day was like Groundhog Day. And for that case, perhaps, maybe so. I don't know. I'd have to see what all they actually said. I haven't watched it yet. The state does not agree that the theory of having cameras in the courtroom would reduce unpredictable behavior for witnesses and other participants. Yeah, probably not. I mean, the normal mode for cases around the world is to not be broadcast. So broadcasting it, I don't think makes people behave better in a courtroom. They, in the old days, they generally behave pretty well, both sides. But the state believes that the cameras in the courtroom will give participants in the courtroom a nationwide platform to further their own agenda, build their brand, promote whatever platform they want, and generally showboat. So you can see there's, last week we talked about, or in my earlier Richard Allen video, I think that was separate, how kind of bland the state's response was to this Franks hearing thing with all the Odin stuff. But somebody dumped the template here and started writing what they felt and bled a little bit of this Odin stuff into this motion. This is no template here, all right? This is custom anger directed into this response by the state. Let's see. I'm keeping a close eye on where people are saying they're from as I'm reading this other stuff. And then finally, the state throws in this high-tech stuff that, hey, you're going to have to contend with deep fakes that intentionally and undetectably alter things that are said in court, giving an accurate impression of the actual business of the court. And I haven't really seen that affect the case, and they don't cite one. I mean, it's certainly the idea that you can take something out of context, of course, or people talking about it don't really know what it means or whatever, if something illegal happens. Okay. And I think it is true that the jurors are in the best position to assess everything, credibility of the witnesses and whatnot, because they're actually there. They get the vibe of the room. They see everything, not just what the camera's deciding to show at that moment. So, the people there live have the best view, in my opinion. But the deep fake stuff, I think, is a little overblown. It's like they sat around at lunch and like, what's every possible reason we could come up with to oppose this? Let's put it on here. So that seems to be how they fight up there in Indiana. So this is the case I was thinking about when I mentioned Taylor Schabusiness earlier. Sidney Powell doesn't have the mask on here. Look at her. She's so innocent and nice. She's not mean at all. My God, what is she even doing in court? I mean, the defense said, this was an outrage by the state to put her to trial and then to ask for anything more than the bare minimum of punishment. And so I got some questions about that. She gets 15 years, basically 15 years to life. So I think she's eligible for parole in 15 years. And maybe that's a lower number, depending on how they credit time for various things. But she killed her own mother in cold blood, right? And Taylor, it's a different state and all that stuff. But Taylor Schabusiness is pretty young. She also tried to say she was crazy like this young lady did. Taylor Schabusiness gets life imprisonment. And is that because of how she killed this person? Or, I mean, I guess I feel like 15 years is pretty light for what she did here. She took an iron skillet, hit her mother with it, and then stabbed her somewhere around 30 times in the neck. And then immediately after that, answered the phone pretending to be her mother to throw off the college people that she was talking to, and then lied to police and her family about somebody breaking in and doing this, which really harmed her. I was too crazy to know what I was doing defense, since she was immediately trying to cover it up. And I guess my thought would be, if she were going down the street and she just decided to hit somebody with a skillet and stab them in the neck, take their wallet, would you just get 15 years for that? What if a stranger broke into the home of the mother and beats this woman with a skillet and stabs her 30 times in the neck? Somebody doesn't know her. Would they really just get 15 years? I feel like there's some kind of dynamic here that, like, because it's her daughter and she killed her mother, that the sentence is inordinately light for that. And maybe age has something to do with that too. But it's like, if you kill your parent, it's not really that bad. Kind of like the girl who threw lie on her father and got time served. I'm not saying she should go on life in prison, but it was kind of like, it was just her dad, So I don't know. I feel like that she was crying a lot for herself, not her mother, at various times when she was facing punishment, seemed to be when she was the most upset. But she skated to, I think, the maximum degree one could ever hope to skate. And I listened to the sentencing, and I heard the defense attorney talk about that it was appalling. He used the word appalling, talking about the state asking for more than the minimum. And I think maybe he should have used a word like regrettable, because what's appalling is hitting somebody with a skillet and then stabbing them 30 times in the neck, especially when it's your mother. Now that's appalling. And that's way worse than the state saying she should get 20 years instead of 15, right? So all the outrage, et cetera, is all reserved for the idea of punishing her, when all she really needs is the love and support that she so richly deserves. I'm not convinced that her treatment would be the same if the circumstances were different. She looked different or was from a different type of family. I feel like some of that bled over into what her punishment was. So we'll see. I think they did mention also they're probably going to appeal. So they'll be like Taylor Schabusiness and saying, I don't want responsibility for the crime that I did here, even though clear in both cases, these two women murdered people in cold blood. They still are trying to dodge it on appeal. In this person's case, her punishment is quite light on the front end. So it'd be kind of fun if she got her conviction reversed and then went to trial again and then got life imprisonment. That would be sweet. So maybe she ought to think real hard about how far she pursues her appeal, given how the judge decided this case. Yeah, and I see a comment here saying her family and a large number of people in the community begging for mercy and least possible sentence. That's cool. That's cool. We definitely should sentence people for the same acts based on whether, and I'm not fussing at you, but my point is, if you're a marginal member of the community and you do act A, and you're a reasonably clean looking from a decent family person B who does the same act, we punish the person A harder because they don't have as many people standing up for him. And I think that was the state's argument a little bit, like I have to, seek some kind of similarity in the general community at large. And so it's up to the judge to do it. So I'm not saying the judge didn't do the right thing because it was put into her discretion of what to do. But I am saying I really wonder if there's some kind of pattern in these recent cases of characteristics that you could have, which could result in you getting a lighter sentence than maybe some other people have. Didn't the judge tell her not to count on getting out after 15? Sure, because that's just when she becomes potentially eligible for parole. And again, I don't know if that number can be reversed or lowered, I should say, due to some kind of credits or whatever. But, that's up to the parole board. The judge left that up to the parole board at that point. So whether she gets out right away or not probably depends to some degree on how she behaves once she's in prison, because she doesn't have to get parole at that point. The parole board can deny it, but don't count on it doesn't really mean anything, because my point is that's the sentence that you gave her where she becomes eligible for parole. And that's going to be true in any case where you set a sentence where you can become eligible for parole. Maybe that was more to soothe the feelings of people who felt like, wait, what? But again, there's more than one way to see things, of course. I'm just asking the question here a little bit there. How do these people not think of going to jail when they do vicious crimes? Well, some of these people, of course, are operating under the new theory that your brain is not, I guess maybe it's not new. Your brain's not fully developed until you're age 26 or whatever. So you're less responsible than somebody who's 27 would be. Now, I don't care if that's true or not. I don't think the law should have grace for that. I think, it is what it is. Okay. It is what it is. If you're brutally murdering somebody at age 22, serial killing and stuff, then you need to get what's coming to you. So do appearances matter? Appearances matter when justice is blind? Do they? Was what happened to her here the same thing that would have happened if somebody had broke into the house with no criminal record and just killed this woman? Are we thinking that, or are we thinking that because she was her daughter and a family said, hey, we'd like her to come home, that it's okay? And then of course, remember, it's the judge deciding the sentence here. The jury returned a verdict of guilty, which I think was appropriate, and rejected her verdict, her request that she be found not guilty by reason of insanity. So the jury did their job, and they did it, in my opinion, correctly. And then the judge decides the sentence, which he did right away after they stopped talking. And it's just something to think about there. Everybody can have different opinions on it, of course, but I feel like that the woman who was killed and the punishment that somebody should get for that was largely influenced by who did the killing. That's just an opinion, and everybody can see it differently. And obviously, the world's a better place with some mercy in it, and I don't have as much mercy as a lot of people when it comes to people who kill people. So I'm an outlier there. I am from the countryside, so it is what it is in my mindset. I'm going to hit this topic again, which is hearsay, and just to go over one thing that we've gone through on a couple of weeks ago, because it comes up so much, and we did a member stream on it and all that. So hearsay, what is it? It's a statement that's made outside the trial or hearing, offered for the truth of the matter asserted. We're using the old galaxy brain chart here. Prior testimony, therefore, is classic hearsay because it's a statement that occurs prior to the trial or hearing. Okay. Yes, but sometimes I see it on TV and in court cases and stuff. True. because if it's the other side saying it and it's admission of a party opponent, then it's going to come in as an admission of a party opponent, even if it's a prior statement, whether it was prior testimony or something you told your friend or something you told the police or whatever. So that can come in if it's the other side. If the witness becomes unavailable and the other side had an opportunity and motive to cross-examine, then it can also come in. It's not going to come in just because the person's busy that day and doesn't want to come to court. I mean, it could come for impeachment, but that's only if they do come. So if the witness becomes unavailable, they died, they're in a coma, they have amnesia, and you have their prior testimony, and this defendant had an opportunity to cross-examine and motive, then it can come in there too. So it seems like this is a hard one for people to get because it's prior testimony in a court. Why it can't count as hearsay. So let me show you these things because it's not just me saying it. I'll tell you why I feel this way. Here's from the North Carolina Superior Court judge's bench book to tell the judges what to think about it. A statement is hearsay if it was made in any context other than while testifying in the current proceeding. This includes, for example, a statement made by somebody at home to a family member or while testifying at a previous trial. So that's what the judge would see. Let's look at the NC Prosecutor's Resource online. Hearsay is defined as a statement made, offered for the truth of the matter asserted, other than one made by the declarant while testifying at trial or hearing. Therefore, even sworn testimony given under oath at an earlier court proceeding is considered hearsay when offered at a later trial or hearing. Of course, it can come in if it's covered under an exception, which we just talked about, two important ones. Here's the North Carolina Supreme Court to close out the authority section of this. We first note that prior testimony is itself hearsay evidence. That's pretty clear, isn't it? That's the Supreme Court of our state talking, and that's reasonably understandable. But it can be accepted by the hearsay rule 804b1. And I think that's the one I just quoted about prior testimony if a declarant isn't available. Although such statements are given under oath, they're nonetheless hearsay and presumably no more reliable than hearsay admitted under any other enumerated exceptions. So the idea is that prior testimony, just because it's testimony in court, is not necessarily, it is hearsay to some later proceeding. So let's finish up our evidence lesson here. So you do see hearsay come in a lot, not just for the two exceptions I already quoted you, admission of a party opponent, in other words, the other person, or somebody's dead or in a coma or whatever. So, you know, if they were involved in the same kind of trial before, you may be able to bring that in. But look at the definition of hearsay, because lawyers are big on words, and realize that, first of all, in order to be considered hearsay, it has to be a statement. So if it's kind of not testimonial and not meant to be a statement, then something could come in anyway. It also has to be offered for the truth of the matter asserted. This is a big loophole that lawyers use to get a statement in. Okay. And they're telling the judge, well, it's not because I'm trying to say that what this person said was true. Maybe it's for some other reason, right? Even though your real reason to bring it in is because you want the jury to think this thing is true. It has to be offered for the truth of the matter asserted. And if you can convince the judge you're offering it for some other reason, it's not even hearsay. And then there are exceptions, many, many exceptions, lots of exceptions, present sense impression, excited utterance, things, you know, you're experiencing. And there's lots of exceptions. That the theory is you wouldn't either have time or motivation or be likely to be making something up. So there's some indicia of reliability. So lots of exceptions to hearsay. So you will see a lot of hearsay come into court, and thus endeth this lesson before you all fall asleep on your Saturday morning or afternoon, depending on where you are. And let's see here if there's anything else there. I don't think so. That's all I had for the cases this week. It wasn't too bad. And maybe there'll be some more exciting things come up as watching the docket flow on some of these matters. And of course, if I do try and keep an eye when people make comments about, hey, are you checking this case or that case? And if I can get to it, I will. So if you think I'm missing a really exciting case or an important point, then please feel free to leave me a comment after this is over in the live chat. It'd be harder to find it there. And Saturday night, if you happen to be there, I can't wait for Saturday night here, because what is between us and that is a lot of work we got to do today. Let's see. All right. I am going to fire up this new graphics package that I just did to exit out and tell everybody to have a good weekend. That's it. Thanks. Bye.